Hi again, everyone. It's Rob Ryder, and it's Sunday, February 5th, 2023. And today, show me proof habeas corpus is no longer suspended. I believe that it is. President Lincoln suspended habeas corpus throughout the United States on September 15th, 1863. And I don't believe that's ever changed. I believe it's still suspended. Now, the way you can prove me wrong is by sending me a copy of the Writ of Habeas Corpus. But writs of habeas corpus are not written by the individual asking for the writ. That's the person applying for the writ. The writ comes from the Court of Chancery. That's how it was done in England. Now, whatever our Court of Chancery is who it is, but it's coming from the court. It's not coming from the person applying. The writ of habeas corpus comes from the court. That's the document. That's the proof. If you don't have a writ of habeas corpus from the court, then there is no court. Or there is no writ of habeas corpus. Now, if this is some, patriot mythology court that you made up yourself, well, I'm not talking about you. I'm talking about from the people who claim to have the authority. I want to see their writ of habeas corpus. If there isn't one, then it's suspended. That's how I feel about it. And then towards the end, then plus 3 constitutions, which comes up quite often. And, technically, well, there's only one constitution, and then there's counterfeits. So if you got 3 constitutions, you got 1 constitution and 2 counterfeits. At the best, they could all be counterfeits. Which one's the real constitution? Well, I'm going with the one that's connected as an appendix in the manual of court martials that the military uses. That's the Constitution. That's the one they're defending. If yours doesn't match theirs, then you're wrong as far as they're concerned. Right, I get that. I don't have a problem with it. I'm going with the Army's version, or the military's version of the Constitution of the United States, 1787. And I'm going to show you 2 examples that are out there today that you would say, well, here's the Constitution, that are not the same as it. And the big giveaway in them is when you go look to see who has the executive power. In the Constitution of the United States, the Army uses it, says the executive power resides in the President of the United States. In the 2 counterfeits, it says it resides in the President of the United States of America. Right? It's written plain as day right there for everybody, God and country to see. They didn't hide it. So, but that's secondary. The biggest thing is this habeas corpus. Because if habeas corpus is still suspended, then Lincoln gave a relief that we're supposed to go use so that we're not affected by it. Hey, I'm Staff Sergeant Robert Allen Bertluski, U.S. Army veteran, also known as Rob Ryder. And as I said, my email address is courtofrecord@AOL.com. You can find my videos on Rob Ryder with 3 B's on YouTube. And if you have a court-sealed writ of habeas corpus that's worked for somebody, please send a copy. Or if you have, whatever your 3 versions of the Constitutions are, then send them to me. But send me the frickin' Constitution. I don't want to hear your description of what they are. I want to see them and then say this is this one, and this is this one, and this is this one. If you can't do it, then, you're just talking out your pie hole, which is a common occurrence in the Patriot Corps for whatever reason. When it's so easy to go find the evidence you want to talk about and say, well, this is what it says. I'm not saying it. This is what they said. Right? Instead of this is what I heard. So, hey, let's get on with this. Hang on just 1 second. So if you go to the American Presidency Project, right, you can find all these proclamations and so forth down through the years. And we'll look at 2 of them. One that Lincoln did, and then this one here by Andrew Johnson, which people will say, well, this is the one that ended the Civil War. Now, we know the Civil War didn't end with a peace treaty. It ended with an armistice. So it didn't end because an armistice is a prolonged ceasefire. It's not an end to hostilities. It's just a ceasefire. But let's look at, let's look at the evidence. So it's a little bit easier to see it here, and I wanted to point out a few things more boldly. But this is the one that Lincoln did, Proclamation 104, September 15th, 1863, suspending the writ of habeas corpus throughout the United States. Okay. The clock started. He's going to suspend habeas corpus. Now, what did he have to say? That whereas the Constitution of the United States will ordain that the privilege of writ of habeas corpus shall not be suspended unless when, in cases of rebellion or invasion, the public safety may require it. So let's stop there. So if he's suspending it, then either there's a rebellion or an invasion going on. Well, that's an act of war, right? And so once alien forces or enemy forces, are present, martial law begins, whether they tell you or not. So I'm saying this was the beginning of martial law throughout the United States. We'll go look at the Lieber Code in a second to see exactly what it says. But, so not only is the writ of habeas corpus suspended, we've just gone under martial law. And if it's never been undone by this proclamation, then we're still under martial law. And the writ of habeas corpus is suspended because of this proclamation. So whereas by a statute, which was approved on the day, right, the 3rd day of March, 1863, rebellion was still existing. And whereas by statute, which was approved that day, it was enacted by the Senate and House assembled that during the present insurrection, the President of the United States, whenever in his judgment the public safety may require, is authorized to suspend the privilege of writ of habeas corpus in any case throughout the United States or any part thereof. So he could just do it for state or whatever, but he could do it throughout the United States. Well, what did he do? Well, whereas in the judgment of the President, the public safety does require that the privilege of the said writ shall now be suspended throughout the United States in the case where, by the authority of the President of the United States, military, naval, and civil officers of the United States, or any of them, hold persons under their command or in their custody either as prisoners of war, spies, aiders or abettors of the enemy, or officers, soldiers, or seamen enrolled or drafted or mustered or enlisted in or belonging to the land or naval force of the United States, or are deserters or as deserters therefrom, or as otherwise amendable to military law, right? Military law, or the rules and articles of war, or rules or regulations prescribed for the military and naval services by the President of the United States, might be like the UCMJ, or for resisting a draft or for any other offense against the military or naval service. So we're making it all military now. I mean, military, for all these reasons. Writ of habeas corpus is suspended. Well, if that's the case, and you're in the military, and you're going to court, you demand trial by court-martial. You say, I'm a protected person under the DOD Law War Manual. Right? Subsection 4, it's about all the different classes of persons. And also because of the Geneva Convention. So, anyway, so for all these reasons, he's going to do something. Well, what is it that Honest Abe did? Well, now, therefore, I, Abraham Lincoln, President of the United States, not United States of America. So this here agrees with what Constitution the Army's using, or the military uses, right? The correct office, the one that has the executive power, is the President of the United States. He's saying it. Do hereby proclaim and make known to all whom it may concern that the privilege of writ of habeas corpus is suspended throughout the United States in the several cases before mentioned, and that this suspension will continue throughout the duration of the said rebellion. Well, an armistice didn't end the rebellion, it's just a ceasefire, so it's still going. Or until this proclamation shall, by subsequent one, to be issued by the who? The President of the United States, not President of the United States of America. Who's who they, today, Congress would say, well, the Constitution Congress uses says that the executive power resides in the President of the United States of America. So anything he says doesn't matter. Right? But that this suspension will continue throughout the duration of the said rebellion or until this proclamation shall, by subsequent one to be issued by the President of the United States, be modified or revoked. So either there has to be an end to the rebellion or there has to be another proclamation specifically modifying or revoking Proclamation 104. Okay, and then I do hereby require all magistrates, attorneys, and other civil officers within the United States, and all officers and others in the military and naval service of the United States, to take distinct notice of the suspension and to give in full effect, and all citizens of the United States to conduct and govern themselves accordingly and in conformity with the Constitution of the United States and the laws of Congress, in such case, made and provided. Okay, so having read that paragraph, so, I've already decided, well, I'm going to go ahead and write a couple of judges and say, hey, if the writ of habeas corpus is still suspended, what is it I'm supposed to do to conduct myself as a citizen of the United States during this, time? I don't know if they'll answer it or not, but, it just said, they require all magistrates, attorneys, and other civil officers within the United States and all officers and others in the military and naval service of the United States to take distinct notice of this suspension to give it full effect. So somebody knows something, and that just because they're not telling us doesn't mean they don't know it. Maybe you have to ask them. So, let's go ask them. Okay, so this is what happened, right? And it was all based on, we go back up here where there was a statute, right? That we're going to see that there was a statute written on the 3rd of March, 1863. And that was a really busy day, so there were lots of statutes written that day. And, maybe a couple of them kind of fit together at a hinge point and say, well, if you had these two and you did this one thing, then you would be released from this burden that was placed on because we went under martial law and, the writ of habeas corpus is now suspended. But I'm not an enemy of the United States. I served in this military. So if it's been suspended, that means you need to give me trial by court-martial. Right? We're just going under military rule, military law, or otherwise amiable to military law. Well, what is that in the United States? It's the UCMJ. It's the Manual of Court-Martials. Whatever those things say, that's the new law. But that isn't the courts we're going to. And let's take a look at a few more things. Okay, so now here's the one by Johnson, right? Proclamation 157, declaring the peace, order, and tranquility and civil authority now exist in and throughout the whole of the United States of America. Well, that isn't what Lincoln said to do, right? He said throughout the United States. But this is the one people point at and say, hey, this is the one that ended the Civil War. Now, it's relatively long, and so I'm not going to try to read it all, but it's a lot of whereas. Explaining why he's going to do whatever he did. So let's get down to what did he do. Well, then now, therefore, I, Andrew Johnson, President of the United States, so that's, he's still doing it right. He's claiming to be the President of the United States, do hereby proclaim and declare the insurrection, which throughout heretofore exists in the state of Texas, is at an end, and it is henceforth disregarded in that state as in other states before named, in which the said insurrection was proclaimed to be at an end by the aforesaid proclamation of that day. This is 2nd April, 1866. I do hereby proclaim that the said insurrection is at an end, and peace, order, and tranquility and civil authority now exist in and throughout the whole United States of America. It has no mention of Lincoln's proclamation, saying that it's suspending or modifying it. Right? It's either got to be modified or revoked. Well, it didn't do that. So the one that Johnson did does not end the one that Lincoln did. In fact, it was really just for Texas, and then it says United States of America. Which, that could be argued, well, that's King George's jurisdiction, because he claims United States of America in the Treaty of Peace of 1783. Like it's the name of a, society or corporation or municipal corporation, or whatever the hell you want. That's his. It's his property. Which is, technically different than the United States of America, when the United States is the United States, and it's the United States in this, on a map of this area called United States of America, where America is the continent and the United States is part of it. and you got the Dominion of Canada. You got is it the United States of Mexico? I think it is. And then you got Central America, South, all one complete continent of America. And then there's this area called the United States. So that is more like a description. It's really not the name of something. It's describing something. But there is something named the United States of America, and that's owned by King George III and his successors, which has a a treaty entitlement to be here in the United States, done under the Treaty of Peace of 1783. Okay, so let's continue on. Let's see what else we got. All right, so here's that act that Lincoln was talking about, an act relating to habeas corpus and regulating judicial proceedings in certain cases. Well, it must be the cases he was just talking about in his proclamation. March 3rd, 1863, that during the present rebellion, so it's already ongoing, the President of the United States, whenever his judgment, that's what it said. So long as said suspension by the President shall remain in force and said rebellion continues. Okay, so again, if they didn't suspend the proclamation by Lincoln, then it still remains in force. And if there wasn't certain things that have happened, then the rebellion continues. Maybe we should look at that first. Then we'll come back to this. Because that's in the Lieber Code, or more properly, General Orders Number 100, Lieber Code, Instructions for the Government of Armies of the United States in the Field. No, United States of America here. Where it says in Article 1 that a place, district, country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army. Well, so if Congress said that there's an insurrection or rebellion, that means there's already occupied by the enemy. Right? Martial law is ongoing. Whether any proclamation declaring martial law or public warning to the inhabitants has issued or not. You don't have to tell you it's under martial law. You need to look and say, well, these things happen. We're under martial law. They suspended the writ of habeas corpus. We're under martial law. Right? So, okay, let's say it's, no matter if they told you or not, it's going on. Well, how do you end the damn thing? Martial law does not cease during the hostile occupation except by special three ways now, except by, number one, special proclamation. Well, presidents issue proclamations. Ordered by the commander-in-chief, well, that's the president in his war hat, or by special mention in a treaty of peace concluding the war. Well, that never happened. All there ever was an armistice. So, unless you can find a special proclamation saying it ended, or an order by the commander-in-chief, then it continues. I'm just saying, well, those things didn't happen. They pretended it happened. And there's a reason that they would have done it this way. Because after Lincoln declared martial law throughout the United States, every governor became a commander-in-chief. And at the end of the war, they didn't want to give that power up. They liked being little kings. Right? And so we'll just act like we darn it, but we're not gonna. We're gonna keep that power and use it forever. And that's really what's happened. They're continuing to use the ongoing rebellion because there wasn't a special proclamation, there wasn't an order of the commander-in-chief, and there wasn't a peace treaty. So the rebellion continues, and as long as the rebellion continues, according to Lincoln's proclamation, the suspension of habeas corpus is in force. So what happens if it is? Well, then the Secretary of State and the Secretary of War are directed as soon as practical to furnish the judges of the circuit and district courts of the United States of the District of Columbia a list of names of all persons, citizens of the state, which administration laws are continued unimpaired in said federal courts. So these would be the U.S. courts. Right, the section that stayed loyal to the Union while the Union was under attack. By order, authority of the President of the United States, or either of the said secretaries, any fort, place, state, political prisoners, otherwise, da-da-da, da-da-da, da-da, list of people. Now, do you know that, they have a thing called is it, not the gallows, but, what starts with a G? But it's a form of being in prison without necessarily being in a prison, right? Like the fort is there in the middle and you're out, you just live around it, but you're basically in prison, right? There's no escape, right? So that's, you being, you being a prisoner is more a state of mind than where you are. And so somebody made us all made us all prisoners is a possibility. So anyways, they're supposed to give a list to somebody, and that list is supposed to go. And then in all cases where a grand jury haven't attended any of the said courts having jurisdiction in the premise, after the passage of this act and after furnishing of said list, our aforesaid has terminated its session without finding an indictment or presentment or other proceeding against such a person, it shall be the duty of the judge of said court forthwith to make an order that any such prisoner desiring a discharge from said imprisonment be brought before him to be discharged. Okay, well, that's what I want to do. I want you to tell me, is there, the grand jury's been held, was there an indictment against me? No, then I want to be discharged from the imprisonment that I'm in that, I can't prove. I don't have a piece of paper, but hey, I'm in some form of imprisonment. I want to be discharged. Right? So you're supposed to be brought before the judge. So this would be like, a district court judge of the United States, or who is it? I don't know. That's why I want to find out. Who is it we're supposed to go to? I want to be discharged. Provided, however, that no person shall be discharged by virtue of this provision of this act until after he or she shall have taken an oath of allegiance to the government of the United States and to support the Constitution thereof, and that he or she will not hereafter in any way encourage or give aid or comfort to the present rebellion. Well, as long as we're still paying people that don't have a freaking EIN number, you're giving aid and comfort to the present rebellion. Which includes, the people you write your taxes to. If you go look at your property taxes, it's going to say, make your check payable to the Kent County Treasurer. Okay? Then the Kent County Treasurer is payee, and that name has to have a taxpayer ID number. When you go to get a hold of the Kent County Treasurer with a taxpayer ID number, you don't get any response. Well, apparently they don't have one. Right? So that must mean they're not the government, because the W-9 makes it quite clear that even if you're in the government, you still have a taxpayer ID number. You're just exempt. But it's the way they keep track of people in the United States. The ones loyal to the United States have taxpayer ID numbers, and the ones not loyal to the United States don't have. If you're writing a check to someplace not loyal to the United States, then you're aiding them in their rebellion against the United States. Jeepers. How simple can that be? So, this goes on and on and on, but okay, so all I'm trying to show is, well, there is apparently a way to end your, the coercive force being used on us if we've been somehow charged for something, that whether we did it or not, right? All I need to do is go take an oath to the United States and support the Constitution. Well, I've already done that. I'm in the military, so you want me to do it again? I'll do it again. Right? It's not like a baptism where you only get one. Go ahead and take another one to the Constitution or to the government of the United States. Okay, so like I said, it was kind of a busy day, March 3rd, 1863, because that wasn't all Congress was up to. They also passed this act, an act for enrolling and calling out the national forces, not federal, national forces, and for other purposes. Whereas there now exists in the United States an insurrection and rebellion against the authority thereof, sounds like we're at war, and is, under the Constitution of the United States, the duty of the government to suppress the insurrection and rebellion, the guaranteed state of republican form of government, preserve the public tranquility, yada, 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 and for the maintenance of the Constitution and the Union. It's all about the Union. That's what George Washington said his vision told him. George Washington's vision, before he crossed the Delaware, basically the most beautiful lady he'd ever seen is waving her arm and saying, son of the Republic, look and learn. And he's being shown all these things that would happen. At the end, which would be like right now, the angel comes from heaven with the sword in one hand, the flag in the other, wearing a crown that says Union across the front, saying the Union shall not be destroyed. It's all about the Union. And that lady was the Virgin Mary, because she appears before lots of people. Well, come to find out then, so he has this vision. He crosses the Delaware, apparently against all the advice of all of his commanders, marches into Trenton, and takes Trenton. Now, this is according to, what movie did I see this in? The Crossing, where they, not too long ago, I can't remember, Jeff Daniels, I think, is the actor, is playing Washington, so I believe it's fairly historically correct. They went through some trouble putting this together. But at the end, when he asked, well, how, what were the casualties? There were none dead, no wounded. Right? And they took the town of Trenton or from the Hessians and da-da-da-da. So, and then come to find out, George Washington on his deathbed was converted to a Catholic. And apparently at Mount Vernon, there's a portrait of the Virgin Mary hanging on the wall. Go figure. So, things were happening with that have to do with the Union ever since the time of George Washington. So anyways, we got this act now. Now we're got to be enrolled. And the biggest thing about the act is that, I wanted to show at least, is when you go down here, it's like, okay, so that the greater convenience of enrolling, calling out or organizing national forces, and for the arrest of deserters and spies of the enemy, the United States shall be divided into districts, of which the District of Columbia shall constitute one, which each territory of the United States shall constitute one or more, as the President shall direct, and each congressional district of the respective states, as fixed by law of the state next preceding enrollment, shall constitute as one. So this 1863, Michigan had 6 congressional districts. I guess we would have had 6 of these districts they're talking about now. Right, they're going to share the same boundary, basically. That in states which do not have by their laws been divided into 2 or more congressional districts, the President of the United States shall divide same. Okay. So what are we going to do? We're going to make enrollment districts. And apparently these enrollment districts will have the same boundaries as the congressional district, at least in 1863. And then that for each of the said districts there shall be appointed by the President a provost marshal, with the rank and pay and emoluments of a captain of the cavalry, or an officer said rank shall be detailed by the President, who shall be under the direction and subject to the orders of the Provost Marshal General, appointed or detailed by the President of the United States, whose office shall be at the seat of government, forming a separate bureau of the War Department, and whose rank, pay, and emoluments shall be those of the Colonel of the Cavalry. Right? And so the job of those people is to make sure that everybody else is properly registered. And so, if they were the ones you were supposed to register before and you didn't register, and they were to send a list to somebody who said you didn't register, then you wouldn't be registered. Because this says the Provost Marshal. It doesn't say the Selective Service system. And as it turns out, there's a Provost Marshal General, of course. So that's consistent. Okay, so what are they supposed to do? The Secretary of War to make rules and regulations of the government of his subordinates to furnish them with names and residents of all deserters from the Army, or any land force in the service of the United States, including the militia, or reported to him by commanding officers. Okay, well, who's in the militia? Everybody that goes to Selective Service and gets registered. Except, they don't properly register anybody anymore in Selective Service because they give everybody the same rating of, I believe it's 1H, which is not 1A, so you're not available for unrestricted military duty. Okay, so that the duty, right, shall be the duty of the provost marshals to arrest all deserters, whether regulars, volunteers, militiamen, or other persons called into service under this or any other act of Congress, whenever they may be found, and send them to the nearest military commander or military post. That in each said district there shall be a board of enrollment to be composed of the provost marshal as president and 2 other persons to be appointed by the President of the United States, one of whom shall be licensed and practicing physician and surgeon. So, okay, and then they can be subdivided and yada, yada, yada. It goes on and on and on. And that was 1863. Then in 1864, they modified it again, got an act for enrolling and calling out the national forces and for other purposes. Back this one real quick. I just want to look to see how they titled it. See, here's lowercase national forces. We go to the next one, it's proper case national forces. Right here. How does that work? What's the difference? Okay, here they're saying during the present war, we've gone from just calling it a rebellion. Well, now they're just calling it a war. But that basically these districts then can be broken into counties, and counties can be broken into wards, towns, townships, precincts, election precincts. Each of these, though, is supposed to be keeping a record of who's enrolled and who's not. And then they went on and did it again in 1865. Got another one. An act to amend several acts heretofore passed to provide enrolling and calling in the national forces and for other purposes. So we'll take whatever we did before, roll them all together, call it this now, and, keep spinning, keep stirring the pot, getting the smoke going up. Smoke and mirrors needs to have smoke, so they're making up a bunch of smoke right here. So, excuse me. So one of the things they mentioned in there was an office called the Provost Marshal General of the Army. So, this is the most recent time, although it isn't that recent. It only went to 2011. It's like these people are only there for a couple of years or so. 1 year, right? That's 4, 3. But you can see between 74 and 2003, there wasn't a Provost Marshal General. So what was that all about? Let's find out the history. Congress approved General George Washington's appointment of William Maroney as the Continental Army's first Provost Marshal General, 10 January 1776. Enforcing camp discipline, his functions included maintaining camp jail, supervising the guards, furnishing day, Eventually, they got turned into this corps called whoever they are, the provost troops. History tells us the provost marshal generals were successful in performing their functions during the Revolutionary War, but after the war, the corps were disbanded, and the provost marshal of the Continental Army was abolished. Well, then we come to the Civil War. Congress passed the Enrollment Act that we had just looked at and established office of provost marshal. And so they put James Barnett Fry in there. He's responsible for supervising the whole draft. Okay, so what was the provost marshal's duty? He's the one supervising the draft, especially tasked with administering and enforcing the new draft law. Provost marshal functions included arresting deserters, enrolling men for draft, enlisting volunteers, compiling statistics, yada, yada, yada. Well, okay, that's what they used to do. What else going on? Oh, then it was abolished again, some General Order 66, abolished Office of Provost Marshal General, 1866. It was the same year Johnson wrote his Proclamation for Peace and Tranquility throughout the United States of America, which is the wrong entity, but that's what they put on paper. And then World War I, well, they brought it back, and among the duties of Provost Marshal General was to administer the Selective Service laws and organize criminal CID within the military police corps. Well, sure enough, there's a CID in the military police corps. And until just recently, the Provost Marshal General was in charge of it. But now they have a director taking over for it. Not really sure what that part was about, but then in World War II, doing it again, and, well, this time to include enforcement of the draft laws. And that was discontinued again, and then 29 years without a Provost Marshal General. They did a little research. All these dates having something to do with September 11th or thereabouts. I'm not sure what Secretary's Title 10 authority is, what title they're talking about, but is that Title 10 United States Code or Title 10 of the secret squirrel book in the lower left-hand drawer of their desk or what? But there's a Title X somewhere that gave the Secretary authority. And so then they started it again. Well, every other time there's been an Office Provost Marshal General, right? It's been because there's a war going on or under some form of war and, where you could be drafted. Except for this break here between 74 and 2003. There wasn't one. So, they brought him back. Apparently the enrollment or being enrolled by a Provost Marshal General is back in effect. And if you weren't properly enrolled, well, now you find yourself suspended by the Writ of Habeas Corpus because of, the ongoing rebellion. And without knowing it, you're an enemy of the United States. But what was going on when there was no Provost Marshal General, yet we had the Selective Service system? Well, here's an example. Back in 2010, somebody asked for freedom of information about President Obama's Selective Service records. And in our previous letter, we stated the following. The 1H status assigned to him, to Obama, at the time was not, strictly speaking, a classification. Although it is a classification. Selective Service has not classified registrants since the draft ended in the mid-70s. However, since that time, 1H has been assigned to everyone as a catch-all classification. So it's not strictly speaking a classification, yet it's a classification, right? Assigned to everyone as a catch-all classification. It was not assigned to Mr. Obama as a result of any action on his part or your part, because you got it too, and there is no related documentation. There's nothing to say why we did it. We just did it. Check a box. We're going to check the 1H box on everybody. Don't tell nobody. The formal description of 1H is registrant not currently subject to processing for induction or alternative service. Well, that's correct up until the comma. It doesn't have the shit after the comma in the same sentence. So the truth is this is where they split the truth to use it as so they could say they didn't lie. Although telling a half-truth is a lie. They didn't tell the whole truth. Because it has a longer formal description than that. My point is, even Obama registered, and he registered, got a 1H. And the proof of his registration is right here. Now, right, Obama, Barack Hussein got an address for a current address, but then for permanent address, he put same as above, so he didn't put an address, right? And then current, he gives a phone number, current phone number, it has a phone number. So then they take this, handwritten form, and they're going to put it into the computer. So now we got a clerk between what you wrote and what the official record's going to show. So what does the official record show from this list? Right here. Where is that thing? All right, it's the PF22 or PF23. I don't know what you call it. Registrant File Inquiry Report. where this is supposed to be his selective service number they gave him, right? They put his current address. We saw it was on the form, but there's no permanent address. So he doesn't really live anywhere. He has no permanent address. He's homeless. And they didn't put his phone number in there, right? They gave him 808, but there's no phone number there. Oops, hey, we made a mistake. Well, now we can't get a hold of you. We don't know where you are. And there's the classification, 1H. All right, so is what it is. They did the same thing to you. They did the same thing to everybody. I'm one of the few people that, because of my age, when all this happened, there's like an 18-month period where I never had to register for Selective Service. If you're born between like 58 and 60 or something like that, you didn't have to you never had to register for Selective Service. Okay, so where are we now? I want to show a couple things to do with the Selective Service, and then we'll be done with this. So this is out of Title 32, the Code of Federal Regulation, having to do with the Selective Service and the different classes. Right, subsection 1630.2, classes. Each registrant shall be classified one of the classes prescribed in this part. Well, we just saw on the record there that, well, we didn't do this. We just went ahead and picked one. But nevertheless, this is what they were supposed to do. All right, available for unrestricted military service is a class 1A. Okay, well, that's not class 1H. Is there a class 1H? Well, of course there is. Class 1H. Class 1H shall be placed any registrant who is not eligible for Class 1A and is not currently subject to processing for induction. You get a 1H because you're not eligible for 1A. That's the reason you get it. You're not available for unrestricted military service. There's something wrong with you. Does that mean you're in jail? Does it mean you're incompetent? You got a mental illness, loss of limb, or what? It doesn't really say. It just says you're 1H. So then technically there is no national force because there's nobody there to pick from. Now, elsewhere in this, right, elsewhere we had the duty of the person required to register, right? You, me, the grandchild, your son or daughter, whoever it is, right? This isn't just us. This is our whole families. Right, to complete the registration process by a method prescribed by the Director of Selective Service, and to record thereon his name, date of birth, sex, Social Security account number, SSAN, right, not SSN. SSAN is Social Security account number, current mailing address, permanent residence. Well, we just saw Palma didn't have one. He did give a phone number, but it didn't show up in his record. Right, so I mean, there's errors and omissions in his Selective Service record, your record, anybody who's ever registered. Well, at one time, the person in charge of this wasn't a civilian Director of Selective Service. It was the Provost Marshal General of the Army. He was responsible for it. Yeah, so there's, all sorts of things that are less than perfectly aligned to allow you to say, well, this could be wrong and this could be wrong and so forth. So I'm looking for proof. And so you should be looking for proof too. Let's say you got to make a mortgage payment and they say make your check payable to somebody, and that's going to go here in this number 1 box, right? Because you're going to request their taxpayer identification number. So you'd fill this part down here as requester's name and address. Right? It's not optional. You want to put it in there. Your full legal name and your address. Put it in there. Don't be shy. Right? And then whatever the name of the payee is, let's say it's on your taxes. It says Kent County Treasurer. Put that down there. And send it to them. Say, look, you got to fill this out. I need to have it filled out. Because if you took the time to read all this, you'd find out, well, if you don't, you're going to be the one responsible for a withholding tax. And yes, the government does have to have an EIN number, even if they're exempt. So let me find them. All right, so if you are exempt from backup withholding or factor reporting, enter in the appropriate space for any of the codes that may apply to you. And then it goes on who the exempt payee codes are, generally who they are, right? Corporations and so forth. The following codes identify payees that are exempt from backup withholding. Enter the appropriate code in the space and for. Right? United States or any of its agencies or instrumentalities. A state, a District of Columbia, U.S. Commonwealth, possession, so forth and so on, right? So if this is filled out right and they check the boxes, well, they're exempt from backup withholding. But if they don't check the boxes, right, fill all this stuff out, then they're not exempt from backup withholding. And because you're the one writing the check, you have to collect it. And if you don't collect it, you're the one that's guilty of aiding the enemy of the United States. And so, by making the payor responsible for withholding the withholding tax, it's all on you. Me, us. Just really quickly, there's the evidence. There is an office of the Provost Marshal General. It is in the District of Columbia, which, claims to be the seat of government, at least for the federal government. So there it is. And any other time there's been a Provost Marshal General, they've been in charge of registration for enrollment in the draft. Just enrollment, period. So if you're still going to Selective Service instead of going to the Provost Marshal, then maybe you're not going to the right place, and that put us on the list. And, all these little ways they could have us give up our civil status because of an error in a record. Okay, just one last thing. I wanted to show these different constitutions real quick. Now, here's an interesting thing. I went to earlier. I just put this in again to find them, but I was in looking for Constitution of the United States, and sure enough, look at Constitution of the United States, 1787, National Archives. And we could take a look at it real quick. All right, it says Constitution of the United States, 1787. It doesn't say Constitution of the United States of America. The Constitution of the United States, 1787. Okay, well, there's one. But then, by gosh, and the U.S. Code for the House, Gov, it's got Constitution of the United States of America. Right, not Constitution of the United States, Constitution of the United States of America. All right, it's not a mistake. There it is, Constitution of the United States of America. 1787 with a caveat. So, from the beginning, the titles aren't the same. So anyways, let's just take a look at these three different ones that I found, right? The one I just showed you. This is the one that the Army or the military uses in the Manual of Court Martials. Manual for Military Court Martials, MCM, Manual for Military Court Martials. In Appendix 1, Constitution of the United States, 1787. And it says in its Article 2, Section 1, first sentence, the executive power shall be vested in a President of the United States, and together with Vice President, chosen for the same term, be elected as follows. Now you see here, it didn't say 2 4-year terms, which we're going to see again here in a second. But this is executive power, President of the United States. And that's in the Constitution of the United States, 1787. This is the one the Army uses. To me, this is the Constitution. So let's look at our first counterfeit. Well, it's the one that Congress is using, which they call the Constitution of the United States of America, 1787, which in its, there's Article 3, Article 2, Section 1, the executive power shall be vested in a President of the United States of America. It's a different officer. Right? He shall hold his office during a term of 4 years, and together with vice president chosen for the same term be elected as follows. Well, that isn't what this one said. Vested, where are you? Executive power shall be vested in the President of the United States and together with the President, Vice President chosen for the same term. Nothing about 4 years in there. This is why Trump very well could be, if he can be the President of the United States, if he did the right thing to take the proper oath, then he could be this. Right? But the oath he needs to take, before he enter on the execution of his office, he shall take the following oath or affirmation. I, with no place to put your name in, do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Okay, but if you listen to when they do the oath for the inauguration, Justice Roberts will say, like he did for Trump, right? Donald, what's his middle name? Had it in there. I believe it's Donald John Trump, right? He says, I, Donald John Trump. And then you hear Trump say, I, Donald John Trump. Well, that isn't what this said to say. And then at the end, they say, so help me God. And so they've added a religious test to this oath, and that made it unconstitutional. So unless they take the oath just like you see it here, then the man is not the President of the United States. And if you've been watching my videos long enough, you've seen this a number of times, right? This is the very first law of this country. An act to regulate the time, manner of administering certain oaths, right? That was first oath signed into law after the ratification of the Constitution. Wherein it says in the very first chapter, very first sentence, that the oath or affirmation required by the 6th article of the Constitution of the United States, well, that's the one the Army has, shall be administered in the form following to wit. I state your name, right? I, Robert Allen Retluski. Here you got to put your name in. President doesn't. There's no A. B. There's just I, and it goes on. But in this case, if you were claiming authority under the 6th article of the Constitution, then your oath would say, I, Robert Allen Retluski, do solemnly swear or affirm that I will support the Constitution of the United States. Period. And it goes on to who has to, how to do all this and so forth. And so there's all sorts of people that need to take this. They're all listed in the 6th article. But the clerk of the House is supposed to take it, and so is the secretary of the Senate. They're supposed to take it. And then you go down to the 5th part, and then the secretary of the Senate and the clerk of the House, they're supposed to take another oath. Right? I state your name, Secretary of the Senate or Clerk of the House of Representatives, as the case may be, of the United States of America, do solemnly swear or affirm that I will be truly faithful, discharge the duties of my said office to the best of my knowledge and abilities. Right? For the time being. Well, they're not doing it. Right? I mean, you can't find any records of anybody taking this oath. Right, but here is who had to take it: the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. So you can't add, so help me God. You can listen to Congress. They do take an oath, but they say, so help me God. And it's not the oath that I just showed you. So they're not taking the oath as the Congress of the United States. They're doing it as the United States of America, which is foreign to the United States. Okay, so again, we got the Constitution, right? This is the Constitution. This is a counterfeit. Constitution of the United States of America, 1787. Well, that's a counterfeit. And here's another one. The Constitution of the United States. Now, this one says it's the Constitution of the United States, right? But Constitution is an uppercase. Right? It's not written, all the words aren't written in the same font or the same uppercase, lowercase, in the same case. When we go down here, we're going to find out, see, the Constitution of the United States, it's not a mistake. No, it is an uppercase compared to the rest of it. It was printed under the direction of the Joint Committee on Printing. Well, this Joint Committee on Printing is made up of, well, guess what? Members of the impersonators that impersonated as senators and representatives of the United States. Right? The people that didn't take the proper oath of office that now sit allegedly as the 118th Congress. And this is the 25th edition, so they've been at it for quite some time. But just like the other two, if we, go down to Article 2, the executive power shall be vested in the President of the United States of America. Well, that's not what the Army said, so this is another counterfeit Constitution. Now, I don't know what other errors are in these things. I'm just saying that, there's three. I've shown you three different versions of constitutions. Only one of them is the Constitution, the one that the military uses, and the manual of court martials. Anything else is a frickin' counterfeit. So the one that Congress uses and the one that Congress approved. Under different names. The smoke and mirrors again, but the Constitution of the United States isn't the same name as the Constitution of the United States of America, but it's relied on by the persons that are responsible for both of them. Okay, that's enough on that. I think I made the points I wanted, right? So show me proof habeas corpus is no longer suspended by, showing me a court's habeas corpus, writ of habeas corpus that they've issued. I don't think we're going to find one. And because of that, then, there has to be something we can do about it because we were given relief when they put the act in place. And it has to do with this Habeas Corpus Act, which I'm far from being an expert on. Right? And maybe there's some other one also. But I'm just saying, well, here's one that said, well, if this happens and the president declares martial law, basically, right, suspends habeas corpus, and you become somehow allegedly made a freaking enemy of the state, that they're supposed to send this list to the district court, and the district court is supposed to have the at the time grand jury take a look at it. But if the grand jury doesn't issue any indictments or anything, then you're supposed to be able to be discharged by appearing before the judge, I guess the judge of the district court, swear an oath, right? And if we went in further, you may possibly have to give a peace bond, right? That's what this next section is, given a bond. Then you would be relieved of your alleged criminality, because right now, as long as it's alleged, it's on the books. Right, even though it may not have ever been gone past an accusation that's never been turned into an indictment or presentment or anything else from the grand jury. So one idea for me is, well, I'm going to write to the judge I haven't written to yet. I guess I might as well show what I have done. Is to my local district court judge to ask them. So let me show you what that would look like. To the Chief Judge of the United States District Court, Western District of Michigan, regarding Proclamation 104, suspending the writ of habeas corpus throughout the United States. Chief Judge, by Proclamation 104, Abraham Lincoln, President of the United States, proclaimed and made known to all whom it may concern that the privilege of writ of habeas corpus is suspended throughout the United States, and required all magistrates, attorneys, and other civil officers within the United States, and all officers and others in the military and naval services of the United States, to take distinct notice of the suspension and give it full effect, and that this suspension will continue throughout the duration of the said rebellion or until this proclamation shall by subsequent one be issued by a president of the United States be modified or revoked. Basically took what Lincoln said and put it in my letter. I am one of whom it may concern, who understands that the rebellion Abraham Lincoln, President of the United States, referred to is still ongoing. Because there's no peace treaty, there's no special proclamation, and there's no order for the commander-in-chief. Right? Still ongoing. And I am unable to find evidence of a subsequent proclamation from the President of the United States modifying or revoking Proclamation 104. Because unless the rebellion was ended, or until it's ended by a special proclamation, an order of the commander-in-chief, or a treaty of peace, then the other way is for the president at the time, a president of the United States, to modify or revoke Proclamation 104. So that's what they need to do. So then, in presence of Lord God Almighty, can you please confirm who I need to contact to be discharged in accordance with an act relating to habeas corpus and regulating judicial proceedings in certain cases on March 3rd, 1863? Right, so I mailed that. We'll see if I get an answer. But that's an idea. Okay, if we're under it, how do I get out? Because I'm not the problem. I'm not an enemy of the United States. Okay, I'm going to leave it there. I hope you all found it interesting or not. And, now if you've watched this long, if you watch what gets posted in comments, people will say whatever without providing any proof. Just remember, I'm showing you the documents that say what they say. That's all I'm basing everything I do on is what has already been written. So let it be written. So let it be done. I wish it was that easy. But really it is. If we could get the coercive force, we can make the sword, which is a two-edged sword, cut for us instead of against us, then our problems would be solved. Okay. Have a great day. See you.